We do not have a formal quorum tonight, so we did have a little bit of business in advance of the meeting, but we are not going to conduct the business. This is kind of, these meetings have really been more discussions, and they're not formal decisions being made, so we can move forward. Obviously, we value your time and our consultants' time, so that being said, we're going to jump right into, without some of the formalities, we're going to jump right into Elise's presentation.
Can y'all hear me?
Yeah. Yes.
Awesome. So as usual, if I sort of fade off or something, just wave at me, let me know. Good evening. I am Elisa Duffy Rogers with CT Consultants. With me this evening is Frank Tweevers, who is also with CT, and thank you so much for having us here this evening. Tonight, we will briefly review the zoning ordinance update process, finish the review of the draft zoning districts, and discuss the administrative procedures. I will stop several times during this presentation to answer questions. So the zoning ordinance update is progressing in roughly 4 phases. The first phase includes the analysis of existing conditions, both in terms of the city's built environment, as well as a thorough examination of the zoning and subdivision ordinances. At the end of phase 1, we produced a diagnostic report with our findings and recommendations, and it is available on the city's website. And phase 2 includes creating our revised regulations. The major changes from your current code are being fleshed out, and we are currently in phase 2. In phase 3, we will complete all of the amendments and align the zoning map with the new zoning district. And then phase 4 is adoption of both the new zoning ordinance and the map. We are adding additional opportunities for community members to come and ask questions, and those will be on the Thursday after the Planning Commission meetings. We're calling them office hours. It's at Fort Thomas Coffee from 10 to 11:45, and then from 6 to 8 p.m. as well. Please feel free to drop in, ask questions, and just have our time together to really have a conversation instead of a very formal presentation like we're having here. At the Planning Commission meeting the following month, I will report out what I heard from community members. At the public session last month, 11 community members attended. We discussed some concerns regarding the community plan, the future vision for downtown, the maintenance of commercial tenant spaces, historic districts for downtown, Midway, and Tower Park, the challenges that sometimes community members face when they come to these meetings, the boundaries of the central business district for both downtown and Midway, and then the unique character of the Fort Thomas Avenue outside of downtown. Moving forward, we will be working with these conditional zoning districts that you see on the screen, with potentially several additional overlay districts, which will be talked about more next month. There will also be some refinements to the central business district, which we will be discussing in upcoming months as well. Tonight, we will discuss the neighborhood commercial office district. And as we've previously talked about many times, the foundation of all of these zoning districts is land use. So therefore, careful consideration is needed for the uses that are permitted within the districts and whether they are classified as permitted by right, restricted, or conditional. So we'll start off with the neighborhood commercial office district. It is proposed for 3, I'm going to actually move this microphone over here.
Yeah, that's some feedback.
Y'all still can hear okay? Okay. So there are 3 areas that are proposed to be the neighborhood commercial office district. It's Fort Thomas Plaza, which is currently zoned general commercial. It is the commercial office areas at Highland and Grand, which are a mixture of general commercial and professional office today. And then the small parcel at the intersection of South Fort Thomas and Bivouac Avenue, which is currently zoned professional office. And just for your reference, it's about ½ an acre, so it's a small parcel. These 3 areas have very different development patterns, which requires a targeted approach to the permitted uses. For example, many typical office and commercial uses will be classified as restricted uses, meaning they have certain standards, because they would not be appropriate for that small parcel at Bivouac Avenue. And for example, those would be things like an urgent care or a trade school would be simply classified as restricted so that we can say where they should be, where they're appropriate within this district. One main consideration in this district is should adult and child daycares be permitted in the neighborhood commercial district. Adult daycare was added to the general commercial district in 2016. We've heard concerns about this change and wanted to get your input. If you decide to remove adult daycare as a permitted use, the existing facility at Fort Thomas Plaza could continue, but no new facilities would be permitted. It is also possible to permit such a facility in other of the three areas, whether you're in Grand and Highland and then at Bivouac Avenue, and not have it at Fort Thomas Plaza. So that's our first discussion question. Do you have concerns with the adult daycare and the child daycare that's currently at Fort Thomas Plaza? Okay, so it's currently permitted by right in the general commercial district. Any concerns with continuing to have it as a by right use? What I heard initially was some concerns that it's meant to be a commercial area and you're putting in this civic use. And so people were concerned that we were using up commercial properties for a civic use. But like I said, it was added as a permitted use in 2016. We should also discuss the vehicle and equipment category, which includes drive-through facilities associated with the principal use, freestanding drive-through facilities, vehicle fueling stations, and vehicle sales, service, and rental. As drafted, all of these uses would be conditional uses. So the first question is, do you want to continue to permit or conditionally permit drive-through facilities, vehicle fueling stations, vehicle sales, and service in these three areas? And obviously they'll be conditional, and we can tailor it, for example, to prohibit those types of things at Bivouac Avenue.
Is that a change?
Did we have these as permitted uses before, or?
In some cases, we're getting, for some reason, we're getting feedback. In some cases, they were permitted conditionally in the general commercial district and then excluded from the professional office district. So one of the conditions that I anticipate writing would be, for example, it would not be permitted at Bivouac Avenue, but it would be permitted then at Fort Thomas Plaza and then at Highland and Grand. And we can talk more as we move into that section about what those conditions should be. So this is just a very general question. Are you comfortable with all four of these being conditional uses? And we'll talk very clearly about what's restricted and what's conditional. Okay. The other thing we should talk about is the auto dealership at Fort Thomas Plaza, which will be zoned neighborhood commercial office as a part of this. Should it be a permitted use? If so, should it be permitted by right, conditionally, or restricted?
So what is that zone right now?
General commercial.
So we're proposing to change that zone there?
Right, so we're actually getting rid of the general commercial, the highway commercial, the industrial park, and the professional office, because there was that hodgepodge up and down US 27. And so that one street will be the mixed use district. Then that just leaves these three areas that have to be zoned something. So as we talked about during phase one, it would be a neighborhood commercial office district, and then we would tailor it using the restrictions for either the restricted uses or the conditional uses for those particular circumstances. So for example, we could say that vehicle sales is a conditional use, and one of those conditions could be it has to be on a parcel over 2 acres. Therefore, it would not end up in Bivouac, and it would not end up at Highland Grand, but it would end up at Fort Thomas Plaza. So fundamentally, are you okay with the use that's there? Yes or no?
Yes.
Okay. That's all I need to know.
Well, so, but is our goal then to make all these things conditional so that we can impose conditions on any new uses rather than permitting some of these things in these areas?
So keep in mind, we have 3 buckets now. We have permitted by right, which you come in, you have development standards, you get your, come through here, that's it. We have restricted uses, which are still permitted by right as long as you meet all the restrictions. And that would be things like you have to have an urgent care on a parcel at least an acre in size. If it's at least and that may be not what we use, that's just an example. Therefore, if it's on an acre, it comes to this board through development plan review, fine. If it's something that requires much more discretion, such as a freestanding drive-through, then that would be a conditional use because it would have discretionary standards that are not objective. All standards in the restricted category are objective standards. Lot coverage, setbacks, lot area, those kinds of things. And then if it needs more discretion, it would become a conditional use. So typically, drive-throughs are conditional everywhere because it's very particular to the site. You have to think about it and use discretion. Does that answer your question?
Yeah, I think it does. I guess, but even thinking about that then, I mean, with the conditional, if you say there aren't objective standards with that.
There can be.
Okay.
There can be objective standards in the conditional use. What cannot happen is there cannot be subjective standards for the restrictive use.
Okay, and I mean, I guess, you know, we want to protect our neighborhoods, but at the same time, I think we want businesses, and I guess I'm concerned about making it too difficult for businesses to locate here. And so that's just a concern.
So if you're generally okay with all of those being conditional uses, 3 months from now, we'll come back with what all those conditions are and define when it's restricted, whether it's an objective standard, and if it's conditional, what are the objective and subjective standards. And then if we are uncomfortable with any of that, we can do any number of things. We can take it off the use chart. We can change those standards. We can, if it's very severe, we can create a new zoning district. But right now we're talking at a very high level. You're okay with the conditional use, and then the onus is then on me to create conditions that give you both comfort, that they're reasonable, but also protect your neighborhoods. So unlike the Alexander Pike mixed-use district, the maximum setback is going to be mandated in this district, but no minimum setback. Because no minimum setback is prescribed, a building can be located no further than 45 feet from the front property line because that's the maximum setback. We did not include a minimum setback because there is so much variation in the built environment in these three areas. Currently, the minimum front setback in the general commercial district is 20 feet, and it's 25 feet in the professional office district. As I said, setbacks vary all over the place here. In some places, you have buildings that have no front setback. In some places, you know, it's the Fort Thomas Plaza, the closest building is about 45 feet from the front lot line, and the auto dealership is like 230 feet from the front lot line. There are just an enormous number of front setbacks throughout these two districts, so that's why we didn't use a minimum setback. Again, the Planning Commission is given the authority to grant waivers to these development standards, and we'll talk a little bit more about what that means in terms of procedure a little later in this. The minimum height is 24 feet, and the maximum height is 50 feet. So any concerns about having no minimum front setback and just a maximum of 45? So we do have one question that we need to consider regarding Fort Thomas Plaza. If we have a maximum setback of 45 feet, and this building is set back 213 feet, obviously that is going to make that building non-conforming, which we can consciously do, but we need to know that we're doing that. We can also use the conditions to say auto sales and service can have a different front setback. So that's my question to you. Do you want to make it non-conforming, or when we create these conditions, do you want to say it can have a greater front setback? Okay. So like the Alexander Pike Mixed Use District, the Design Review Board will be charged with reviewing building renovations and new construction. The design standards that we're proposing are very similar. The requirements for building orientation and transparency and architectural articulation for the facades. As we discussed last month, facade openings would have to be vertical. Y'all had concerns about that, and we agreed to take it out of, Alexander Pike Mixed Use District. So I'm assuming we want to take it out of this one as well. The standards do require durable materials adjacent to the ground or the sidewalk, and that rooftop equipment must be painted or concealed. There is one additional standard here that we did not have in the mixed use district, and that is requiring that the buildings at the corner of Highland and Grand do something that architects call address the corner. It forces them to move front to the lot line and then to have buildings at those lot lines so that you can define that corner. And so that's required by these as well. Also, all the parking would have to be behind the front facade in these four locations, these four corners. Of course, one of the corners is obviously a park right now. Any concern with any of these design standards?
So what does that do to the existing buildings then? That we've got parking in the front does that change anything with that? If that use changes, then they've got to get rid of the parking in the front?
No. It would just be grandfathered in, it would be non-conforming. If the use changes, then they could just continue to operate as they are. If the building for Chase Bank comes down, for example, then they would have to meet these standards. So we are consciously, it's a really good point, right? I mean, we are making a decision here that all of those buildings are going to become non-conforming.
When you say use, does that also mean that it became an office as opposed to a bank?
It's the same, yeah. It can continue to operate
Gotcha.
Unless it's torn down.
unless it's torn down.
And then it has
Right. Now, it becomes a little bit more of a gray area, for example, and we'll talk about that in a few minutes. They probably have non-conforming site conditions there. They probably don't have enough trees in their parking lot, all of those kinds of things. But that has nothing to do with what we're talking about here. That building can continue to, it could become an office, it could become any of those things. And the gas station can continue to operate. If it became an Amoco instead of a BP or whatever. Any concerns? In the neighborhood commercial office district, the parking reduction is for the provision of civic open space, and we talked about this last month. They can actually not have to provide parking for those square feet that you see on the screen if they provide this civic open space. So the question to you is, and if you'll notice that it's graduated. If it's a tiny little plaza, they don't have to provide parking for 2,500 square feet. If it's a green, it's more than a quarter of an acre, then their parking reduction is 5,000. Any concerns with incentivizing these gathering spaces in these three areas? And it's a small incentive, let's just be honest about it.
And can we waive those then as well?
Oh, no, this is an incentive. They don't have to do it. But if they choose to provide a plaza, yeah, it's just an incentive. They don't have to do it. It just gives them, you don't have to provide a little bit of parking if you give us a little bit of open space. Again, the parking would be required to be behind the front facade of the building unless a waiver is granted by the Planning Commission. But then we also need to think about the dealership again. And we can put in the conditions that they don't have to follow that requirement. Is that what you would prefer? I mean, I think it makes a fair amount of sense to allow an auto dealership to have parking in the front. So that's why I'm...
The other way that I have heard the argument for that is their parking isn't really required parking. It's what they're selling, so it's not required.
Yeah, I mean, and truthfully, some places are so adamant about not stealing cars from right of way that even if it's not required parking, they force it to be at the side. I think we're in a situation where they exist. It's a valued member of the community. They don't actually have the depth to do that. They would have to move their building. And it is what they're selling. So that will be part of the conditions that they don't have to move that. we'll stop here and take questions. Yes?
Yes, so if you all have any questions, we'd like you to keep it to 5 minutes if you would mind, but please step up to the podium and if you don't have your name signed in, sign it in and provide your address. And once again, we are focused on this topic, the neighborhood commercial zones. If there's anything else, we'll save that for another night. Please stay focused on the neighborhood commercial zones for this question.
I live at 66 Burning Lane, and my question is specifically about the neighborhood commercial zone. If I'm not mistaken, and this is already been answered, there's consideration to somehow merge several mini zones into one new, kind of more universal zone, for lack of a better word. Not knowing details of the specs at this point, I'm only asking tonight that non-conforming buildings in existing zones not get automatically grandfathered into the new zones. A non-conforming building in an existing zone should not be accepted into any new zone without close examination and evaluation. At one of the informational, and they are great, morning after meetings at CT at Fort Thomas Cochran, Elisa heard about the storage opportunities on the property of 600 South Fort Thomas Avenue at the top of Midland, currently zoned PO. Her comment sounded lighthearted, but was both true and noteworthy. She said, there are conforming uses, there are non-conforming uses, and then there are illegal non-conforming uses, which I got a tickle out of because I thought non-conforming we're very well aware of. But most people in the meeting, in that little meeting had never heard about these storage bins, facilities, whatever behind that. So that being said, a blanket grandfathering, in this kind of goes to your point, Tim, the blanket grandfathering of any existing non-conforming uses should be avoided. I think it's a case by case. Don't grandfather them in. Many may still go in, but I think a blanket is bad since a lot of people don't even know that there are these ones that aren't even considered non-conforming. They're considered not allowed.
So the only thing I would say is that we really have no choice. If it's a legal non-conforming, and we're going to talk about this a little bit more in a minute, but there are non-conforming structures, which means the use that's in it may actually meet the zoning ordinance, but the building does not, because it's too close to the front lot line or too far from the front lot line or something like that. So let's make sure we distinguish, and again, we will spend a lot of time talking about this in a few minutes, distinguishing between the use and the structure. So let's talk about, and in both situations, it can be legal, meaning it was established under regulations that were in effect at the time, or it existed before there were any regulations. So it is a legal non-conforming use or a legal non-conforming structure. And we by law have no choice but to allow those to exist forever, essentially. Now, if it was established illegally, it was never permitted in the district, then that's a whole different animal, and they do not have those legal protections. But if the use or the structure was established or built before there were zoning regulations or under regulations that were in the past, we have to continue to allow those to exist. And I know it's sometimes troubling, but we don't have any choice.
Your explanation is extremely clear, which I find I'm very grateful for. I'm a little curious, how do we find out if that was illegal, if they're illegally doing a storage container? If nobody knows about it, like you need a little secret code to get in behind the building and use your little storage box and then leave in the dead of night. I mean, I was astounded when I heard it, and other people were, and this is what I'm talking about. And it was someone who lived nearby there and said he was aware of it because he saw it.
Right. So that would be an enforcement issue. And sometimes it actually becomes a detective issue as well. Because you have to, in terms of enforcement, you have to figure out what's actually happening. And then you have to figure out, if you can, when it was established, and then whether or not there were ever any zoning regulations that would have permitted it. And once you go through that whole process, if you find out that it is actually, an illegal use, then you start enforcement through the zoning ordinance. And Kevin wants to say, and Mark wants to say anything more about that. But that's how the process typically works.
Interesting. And I would assume part of the legality of it is a business license, which is kind of not your area. But I'm just sort of thinking out loud, speculating, because this piece is so new. Certainly, they have to have a business license to be getting the storage units. Okay.
I don't know whether or not the city requires a business license or not.
We do, but under those circumstances, I'm not certain of how that would, if it's for the entire building, or each individual use, I'd have to dig in a little bit. We have to do some research on that particular site. I don't deal with business licenses per se, so I'd have to do some digging.
Thank you.
Oh, no problem.
We can't hear. We can't hear. Do you have a microphone for her?
Mike, I'm sorry.
Thanks.
Nobody says they can't hear me.
I don't have that problem either, so.
Unless I ask my husband to do something, he's like, I didn't hear you. I thought I was too loud. See?
As long as it's in front of that speaker, okay, I don't think it's gonna, I don't think it's gonna work.
You might want to turn this down. Okay, so I know I'm not just talking about this zone, I'm talking about every zone that we're talking about. Our community plan talks about a city and a park feel. So my question is, how do we create some density and some requirements behind all of these districts that we're coming up with that kind of create that, I would say, tree barrier, if you will, between these districts and the residential areas, whether it's this district or another district. Are there things that we can require as part of the zoning that require people to put up trees to prevent the noise and the light and all of that? I'll give you an example. We going to say something? Oh, I was just going to say, when people change the use, like maybe it could be general commercial, or it could be this office district, but when they change what they're using it for, like let's say before they had parking behind the building, and now they have huge trucks behind the building. Well, now that goes above the existing trees that are there. There's no barrier between the two anymore. So if we're going to create a city and a park feel, I feel like it would be remiss of us not to include that in some of our zoning requirements.
So buffer yards between uses, you have currently, to a certain extent within your ordinance. We have not gotten that far in the draft yet.
Okay.
But I'm going to be really honest with you. If, for example, it goes from Chase Bank to Wells Fargo, or it goes from Chase Bank to Dr. Smith's dental office, we have not the authority to force them to put additional buffering in because they exist, and they existed in a time, just what we were talking about before with Ms. Ferris, they existed in a time before those buffer yards were required. So we will be looking very closely at how you transition from these commercial districts, whether it's along US 27 or at Fort Thomas Plaza or whatever else, to the adjacent residential. But I don't want you to think that even if we put substantial buffer requirements in, that that's really going to do anything. If you're in a situation where it's an existing property, that just may change over time. Now, if it's an issue of loading, that's an intensity issue that may allow us.
If it's an issue of what?
Loading, the trucks are loading.
Oh, loading, okay.
That's an intensity issue, which may give us some authority to then require additional buffering or screening, whether it's fencing or trees or whatever else. But in many situations, you're living with a situation that even if we create these standards for screening, you may still have to live with the situation that you have. but you're not the first person to give us very real concerns about those transitions from business to commercial. I mean, from
Yeah,
business to
and this
residential.
is an example where it was like a mailing facility and now they're doing U-Haul trucks, for example. I don't have any issue with the business itself. I'm happy the business is there. Again, how can we just buffer and make sure that that's included in our zoning to the extent that we can?
Yeah, we will. We will, and we'll get to that probably 3 or 4 months from now.
And then one other question, where would a storage facility fit in this scenario?
Nowhere.
Okay, great.
Lisa, is that accurate? Because I think we still have in our, we're doing away with the industrial, because I think that allows warehouses in the industrial area.
So we are, the industrial IP district would be gone.
Okay.
Yeah, and so there are, but there, again, let's define our terms. Warehousing is one thing, mini storage is another, and then a third thing is, you know, the outdoor storage for your RV or whatever. In all of the districts as they are currently drafted, mini storage and that kind of thing is not anywhere as a permitted use within the city of Fort Thomas. As the districts are currently drafted, now, that doesn't mean it will end up that way, but that's where they are now.
Hello, I'm Hillary Landner, and I live on Woodland. I want to just try to visualize something you were talking about when you said that the commercial properties at Grand and Highland are non-conforming because they do not address the corner. I was wondering, do you happen to know if we have any places in Fort Thomas that do address the corner? I'm trying to figure out what that would mean if something happened to one of those buildings and they had to redo it.
It would mean bringing the building closer to the street and having a street wall or building wall on both corners. So that instead of looking at parking, you would be looking at buildings.
So it would be right by the sidewalk. Like
Not necessarily, no, because there's no minimum setback in that district, it's a maximum setback. But what would be defined at this point is that as it's currently drafted, is there would be no parking between the front facade and the front lot line. And that would be on both sides.
And I don't think we have anything in Fort Thomas that does that.
I'm trying to think if there's any buildings that address the corner.
Yeah, or if you happen to see one nearby.
But even like the building that's at the intersection of Brentwood and Grandview, I didn't grow up here, but I think somebody told me it was an ice house.
Yes.
Okay, I'm correct. Awesome.
Yes, that is one. That is a building that doesn't.
Yeah, okay. No, I was going to say, because one Highland, I don't want to talk about one Highland.
But yes, that is a perfect example of how a building addresses the street. Thank you.
Thank you.
But again, we're not in any way saying anything is wrong with Chase Bank or BP.
No.
Just at some point in time, if those properties redevelop, let's have them define that corner. And the reason it's important to address a corner is because it says this is a place. This is Grand and Highland. This is an important place within your community. Instead of, here's a place with a bunch of parking lots. So that's why it's important. And you can decide that it's not important. But, you know, it's an urban design consideration that is not currently in your code.
In St. Jeffrey, example of that, when I was trying to think of one, there's the church, and I think that they have a little half wall, and it's at the corner of Rossford and Northford Thomas.
I don't think so.
I can't visualize off the top of my head, but what you're describing makes it sound like it would, yes.
Just a church, and the parking lot's all on the side. I do believe, and refresh my memory, I think they do have a half wall.
Well, they have like a plaza with steps that come down. It's the church
The
is
church.
not 40. I don't believe that the church is 40 foot away from the right of way. It's up close to the corner.
Probably.
Yeah, I mean, I think that's a great example.
Yeah.
Of course, it's not a business.
It doesn't matter. You know, we don't care about that. What we're caring about is creating that sense of place at Grand and Highland. When I first came to work here, people kept talking to me about Grand and Highland like it was, you know, a defined place. And it is to a certain extent. But let's make it a place.
I just want to talk briefly because I like to reserve my time, but just a couple things, and Alicia, it goes back to what you were talking about your meetings you've been having with the citizens, which are fantastic. But one of the things we talked about this last one that you briefly touched on was the meaning of the comprehensive plan. Because last time we heard one of the members talk about how what happens here has to be guided or almost dictated by the comprehensive plan. So we asked Elisa what the comprehensive plan is and what that means vis-a-vis this committee or this commission. What she told us was, and Elisa, feel free to stop me or to change this, but she said that the comprehensive plan is a guiding document. In no way does it ever have to be implemented. I think I'm quoting this. In no way it needs to be implemented now or ever. It doesn't mean that everything in it needs to be implemented. It has no legality as it stands, and we can pick and choose what's relevant. And I think that has been borne out by the splash pad, which is in the comprehensive plan, but is not going to happen now. So I just wanted to bring that to this committee, and I'm going to say there's not everybody here because I think Mr. Norm is who brought it up last month. So, and you can address that later, but I just wanted to be sure we had that at the full committee here that we talked about at that meeting that day. Secondly, I wanted to talk about our sense of place and the value of bringing buildings to the corner, because it is a big change. I mean, as you, all of you who have lived here a long time, Highland and Grant has been that way for at least 68 years. At one time, I think we had either 3 or 4 service stations there, so we've always had the buildings setting back. So when we're looking at our sense of place is parking in the front, especially at Highland and Grand. Down at Fort Thomas Plaza, I don't even know how we put parking in the back because right now it's 100% parking in the front. Lisa told us at that little neighborhood meeting that you asked what the goal was of this entire process. And she said 2 goals. Number 1 was right sizing, having the zoning code reflect what's actually on the ground right now. So I just love for you all to consider and for Lisa to explain to us all what is the value of changing what we have right now. And I think Mr. Michael brought that up last month, that you said you keep hearing over and over again, we want to keep what we have right now. But apparently that's one of the goals of this whole exercise is to keep what we have right now. And then thirdly, I just wanted to point out, Bivouac is very different than Fort Thomas Plaza or Highland and Grand. And, you know, I don't know about you all, but I've been pulling in and out of the parking lot for One Highland because I like Fort Thomas coffee. And it's difficult. It's difficult to pull out there. And my fear is, you know, I think all of us want the kids in Fort Thomas to be able to ride their bikes. And I'm afraid if we move all the parking to the back, we're going to have a consideration with difficulty pulling in and out of these businesses. So that's all for me, but I just want to bring, I don't know why Bivouac is being put in with, like Fort Thomas Plaza, for example. They're so very different. Fort Thomas Plaza is really like the rest of Alexandria Pike in terms of this commercial area that's, you know, business, 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 whereas Highland and Grand has always been what it is now, and Bivouac has been professional offices for a long, long time. So I'm not sure what the thought was in putting all that together, but I'd sure love to find out what the value is in all this, other than it's an architectural concept or it's something that's, you know, in the academic journals. Thank you.
So again, let's separate the idea of urban design and use. So you have 3 distinct areas, Fort Thomas Plaza, Highland and Grand, and Bivouac. Right now, they are a hodgepodge of zoning. We are creating one, and we talked about this during phase 1, creating one zoning district, and then as I talked about at the beginning of this, there are very, very different built environments in those 3 places. So we will use the restricted, permitted by right, and conditional categories to limit what can go, for example, at Bivouac. And one of the restrictions I said was it would be a restricted use for an urgent care, for example. And one of those standards would be it has to be on a lot of Y size, or it has to be located on a street of this magnitude or whatever else, so that we tailor the use so that only the uses that we think are appropriate end up at Bivouac. If through this process we get to a situation where we feel like we actually do need to create a whole other district for that half-acre parcel, we can do so. But right now, we are attempting to limit what goes there by deciding what the uses are and whether they're permitted by right, restricted, or conditional. But if we get to the end of this process, after we've defined all of those conditions, and we're unhappy with that, we still aren't really happy with what we're creating, for example, at Good Plat, then we'll create another district. And then if you want to talk about sense of place, that is done through where the building is on the lot. That is very different than use. So it's two different and separate considerations.
So addressing that, what you're talking about with the building placement is you're going to put building placements all the way to the street where right now they're not at the street.
No.
Okay, I just thank you, I appreciate it.
So for this neighborhood commercial office district, there is no minimum setback, there is a maximum setback. So the buildings can be anywhere at the front of the lot if they choose to be so, or they can have a maximum setback of 45 feet. Because these are very different environments, I felt it was important to have that flexibility in terms of where the building goes. So we are not necessarily, within these three parcels, we are not mandating where the building has to go on the lot. It can go anywhere from the front lot line to 45 feet back. And right now, front setback for general commercial and professional office is either 20 or 25 feet. That is a minimum setback. So they can't be any closer than that. They can be as far back on the lot as they want.
But the parking would have to go in back.
As it's currently drafted, the parking would have to be to the side of the building. What it says, it has to be behind the front facade. That doesn't mean it has to be all the way to the back. It just has to be behind the front facade. So that the character of the street becomes something besides cars.
Lisa, has the Highland Plaza been addressed in this? Because when I think of the Highland Plaza, it seems way more closely, I mean, it's way smaller than Jeff Weiler is, but it's a strip of individual businesses with ample parking.
Right, but the parking is all to the side. Every single bit of it is.
Well, no buildings in the front.
But all the parking, I know there actually may be two parking spaces, but we're talking about where cobblestone used to be?
Yes.
Yeah, so all of that would be fine. The building is, 20 feet or something from the front lot line. I measured it the other day.
Cobblestone?
I think, or maybe it's 10 feet, something like that. It's really close to the front lot
But I
line.
think, I didn't think that the address was, I mean, they don't have an entrance from the front, it all comes in from.
Yeah, and that's actually the perfect example because the building is closer to the street and the parking's to the side. And that's what these requirements would be. So nothing about that building would be made non-conforming.
But would that be done in with this?
Yes.
Okay.
Yeah, it would be. I apologize if I didn't mention that.
I don't think I answered it in that way. I just, in hearing these areas, the top of it, being addressed, and that's such a itty
It is, and yeah.
but it's pretty natural to those who live by here.
And I don't mean to diminish that at all.
No, I agree with that, but the Highland Plaza is big
Mhm.
and seems worthy of hearing.
And it would be under this proposal, it would be neighborhood commercial office. So it can continue exactly as it is.
Thank you, I appreciate that.
My name's Ken Honcho. I live on COVID Place. I can throw this hour speech away because I didn't know it was going to be confined like this. So I just had a few questions that I couldn't hear answers to.
Yes, sir.
Is the rezoning plan we got last year was all over the place. I mean, there are a lot of rezoning areas in the city. Are they still being looked at? Or is it just now we're talking about these commercial areas?
So, I'm not sure what you're referring to from last year. But what I will say is this. All the residential districts that currently exist today, R1, R1B, R1C, all of that, are being unchanged. Those lots are not going to be rezoned. They will continue to be single family. What we're talking about are the three areas here, and then the commercial zoning along US 27 and Alexandria Pike.
Okay.
And then we will be talking about the Central Business District in a couple of months.
Okay. So
But 90% of the city will be unchanged in terms of the actual district. Some of the standards in the district may change,
Okay.
but the districts themselves remain intact.
That answers my question. Thank you.
So when we move on to the administrative chapters, the Unified Development Ordinance, Article 1 of the UDO contains the general provisions and the administrative chapters. You may notice that the packet did not include definitions. It's way too early in the process to flesh those out, but all the other administrative chapters are there. Much of the existing procedures that you have for development plan review and zoning amendments and all of that are included in this article, and any changes to the existing provisions are noted in the draft with deletions lined out and new provisions in bold and underlined. Section 1.2 establishes all of the zoning districts. You will notice that there are both regular or standard and special districts. Special districts are like overlay districts that lay on top of the conventional zoning districts. As I just said, all the single-family districts are being retained with one additional, which is the R1 CPD that we talked about a couple of months ago. The general commercial, the highway commercial, the professional office, and the light industrial research districts are all being eliminated, as we've discussed, and they are being replaced with the Alexandria Pike Mixed Use District and the neighborhood commercial office that we just discussed. Section 1.3 includes the powers and duties of the zoning administrator, the city engineer, the planning commission, the tree commission, the zoning review board, and the board of council. These boards and personnel are charged with administering, interpreting, and enforcing the Unified Development Ordinance. Section 1.4 is the development review process. The development review process generally moves in stages that you see on the screen. The only real change to the process as you currently have it is we are expressly calling out that there is an optional pre-application meeting with staff. We did remove the application submittal requirements from the ordinance, and these will be on the development plan application. We included for the first time review criteria for the planning commission and the zoning administrator to use as they are evaluating stage 1 and stage 2 plans. As you know, the stage 1 plans are more preliminary plans that are reviewed by the planning commission. The finalized or stage 2 plans are reviewed and approved by the zoning administrator. That is your current process. The existing administrative review procedures and this draft provide that the zoning administrator can only require stage 2 if it's a very minor change, in which case it would come to the planning commission and nothing else would have to go to the zoning administrator for approval. Your zoning permits are being retained. Zoning permits are issued after the completion of the development plan review process, and they attest that the proposed development complies with the ordinance and development plan review. New is their certificate of zoning compliance, and it replaces the current requirement in the ordinance for a certificate of occupancy, which can be confusing because it sounds like an occupancy certificate, which is in the building code. So we're removing that level of confusion. The certificate of zoning compliance is a document issued by the zoning administrator, which certifies that the project, as constructed, is completely done, in most cases, complies with the ordinance and development plan review. Section 1.6 is the conditional use permits. The existing process for the conditional use permits is being retained, and this requires review by the Board of Adjustment. As is currently the case, in order for the Board of Adjustment to hear it, the use must be listed as a conditional use in the district. Conditional uses are only heard by the Board of Adjustment, and in this case, they will also look at the development plan review as well as the conditional use. So in that limited situation, development plan review would not come to you, and that is currently your process. Section 1.7 is appeals and variances. The draft section clearly separates appeals from variances. The current zoning ordinance conflates both of these processes, which is confusing. Appeals are appeals from the decision of the zoning administrator. Variances are requests to deviate from the dimensional standards in the zoning ordinance, both of which are heard by the Board of Adjustment. The existing process for variance is being retained, which, as I said, requires review by the Board of Adjustment. Section 1.8 is amendments. This section includes existing processes for both amending the zoning map and the zoning text. There is review in the public hearing by the Planning Commission and review and consideration and adoption by council. Here comes the crazy section. Section 1.9, nonconformity. This section clearly distinguishes between all the different types of nonconformity. Your current section does not. There are nonconforming lots, nonconforming uses, nonconforming structures, and nonconforming site conditions. The nonconformity provisions recognize the existence of land uses, buildings, lots, structures, and site conditions that lawfully existed at the time because either, as I said previously, they were enacted prior to there being a zoning ordinance, or they were enacted legally under a current zoning ordinance, but aren't anymore because the zoning ordinance was amended. In terms of nonconforming lots, that means the lots are either too small in terms of area or too narrow. No big changes are planned here, except that your current ordinance doesn't recognize that a lot can be nonconforming because it's too narrow. Nonconforming uses are uses that are no longer permitted in the zoning district, but were permitted prior to the zoning ordinance being amended or enacted. For nonconforming uses, we added that nonconforming uses can't be expanded, that the relocation on the site is restricted. We defined when structural alterations are permissible. We added provisions explaining what happens when a building housing a nonconforming use is changed. We retained the process that is currently have, that if a nonconforming use is changing to another nonconforming use, it has to go to a Board of Adjustment. So when we're considering a nonconforming use of land and it ceases, because at that point in time, as you probably know, if a nonconforming use ceases, we do have some ability to not allow a new nonconforming use to reestablish itself. There are two different instances when this happens. When it's a nonconforming use of land, and when it's a nonconforming use of a building. If it's a nonconforming use of land, we are saying if the use ceases for 180 days, it cannot be reestablished. Do you have any concerns with that? And again, we're just talking about a nonconforming use of land. For existing nonconforming residential uses, and we've talked about that there are several of those that exist, meaning there's a single-family home, for example, that is now zoned commercial. What we have included in this draft is that that structure may be enlarged or altered, provided that no additional dwelling units are added. Because as we've talked about previously, in these situations where we have single-family homes that are zoned commercial, they are a non-conforming use, and they cannot extend or expand. They can't add an addition, they can't put on a bigger deck, they can't do any of those things. So this change to your existing language would allow that to happen. If it's a residential use, it's non-conforming, and they're not adding any more dwelling units or any of those kinds of things. Do you have any concerns with that change? So non-conforming structures. So non-conforming structure is a building that was already built when the zoning ordinance was enacted or when it was amended. Non-conforming structures, which are buildings that don't, for example, meet the setback requirements. That's how it becomes a non-conforming structure. As we have talked about previously, many of the homes within your community are non-conforming structures. We retained the existing provisions for non-conforming structures and added that non-conforming structures can be expanded as long as the use is conforming and the expansion does not increase the non-conformity. So there are two specific examples that I want to talk about. A non-conforming structure which is designed for and devoted solely to uses permitted in the district may be expanded if it does not increase the non-conformity. Do you have any concerns with that? We've also added that if a single-family home has a non-conforming side setback, they can extend along the same line, provided that if it's less than 5 feet, it still has to go to the Board of Adjustment. So that's a fairly significant change. Any concerns? So let me give you an example. Minimum side setback is, for example, 8 feet. And they're sitting at 5 feet. Do you have any concerns if they extend along that same line along the back of the house? Okay?
Well, what about if they're sitting at 2 feet?
They have to go to the Board of Adjustment. If they're, because I think we could all agree that someone needs to look at. And then finally, we come to non-conforming site conditions, which is, for example, when she was talking about the lack of buffer yards. That would be a non-conforming site condition. Or if the buffer yard is too narrow, or it doesn't have the right planting in it, those kinds of things. The parking lot doesn't have enough trees. They don't have enough parking to meet the required parking requirements. Those are all non-conforming site conditions, which your ordinance is currently silent on. So as drafted, if a parcel is going to be changed, the site's going to be changed, it will come here, have to meet the current standards, but you do have the latitude of allowing approvals if they do the best they can to come up to standard. So we're not unnecessarily restricting their use. In section 1.10, the existing ordinance already permits waivers, but you don't really have a process by which you examine those. So because, and for example, one of the waivers that's in your code is right, you can waive the parking requirement in the central business district. That's one of your authorizations right now. This section expressly codifies your ability to grant a waiver and use your process. Again, keep in mind that a variance is from a dimensional standard only. In Kentucky, variances are only allowed for dimensional standards. As a result, I'm going to keep saying that again and again. You then have many situations where you might want to grant some relief and you're not allowed to do so. So many communities in Kentucky use this waiver system. Section 110 lays out the process, requires that they give an application, a specific application process, that they have a statement of justification, and the Planning Commission is required to make certain findings before approving the waiver. And they're allowed to put additional conditions on it. So as currently drafted, the zoning text includes specific instances only where the waivers may be granted. This defines the authority of the Planning Commission and alerts users of the ordinance where the Commission envisions that a waiver is necessary, potentially. There's only one disadvantage to this, which is we may not always think ahead of time when you can grant a waiver. And if you're not expressly authorized to do so in the ordinance, then you can't. That's the way this has been written. Some communities will just say, if it can't go to the BOA, the Planning Commission can grant a waiver to everything. That becomes problematic, which in inappropriate situations. So there are only specific instances in the ordinance as it's currently drafted where you can grant a waiver. And we've talked about that would be, for example, of parking in the front. That would be a place where you can grant a waiver as it's currently drafted. To counteract the fact that we may not always think ahead about when we needed a waiver potentially, there's something called an equivalency provision. And that's on the screen and it was also in the packet. This allows the applicant to propose an equivalent method of meeting a zoning ordinance standard. So in other words, the applicant is just satisfying it in a way that we didn't think about. So my first question to you is, in terms of waivers, do you want that very large, overarching power that you can grant a waiver to everything? Or do you want to keep as it's currently drafted, that you can only grant a waiver in specific instances?
I think I'd be in favor of having it fairly broad.
Okay.
But, for instance, you mentioned the parking, if instead of just specifically addressing parking, if you address site conditions, you know, just a broad category that if the site, you know, lot size, whatever else, doesn't allow for something, whether it be parking or setbacks or whatever else, that you have the ability to do the waiver then. I'm not sure how that gets drafted, but I mean, it wouldn't just be parking, it wouldn't just be buffer areas or something like
So as the non-conforming site condition is drafted, it says that the planning commission can determine that conformance is not reasonably achieved and ask them to bring it up as much as possible. So that's actually a separate section under non-conforming.
So what are you talking about on the equivalency provision? And I mean, are we talking about the buildings themselves, the setbacks?
It can be any number of things. It can, you know, for example, let's say you're required to have one parking lot. It's a brand new site. And you're allowed to have, you're supposed to have one parking lot tree for 10 spaces. And it's supposed to be an individual island. It's a very common statement. Well, you can have an equivalency provision that says that will require you to have 20 trees, but because your site is oddly configured, we're going to allow you to have 2 trees in an island and still have 20 trees instead of just having one in an island all throughout the parking lot.
So is that the same thing if I'm asking for then, that it gives you broad discretion?
Yes, it does.
Okay.
But I think when we get to the end of this process, we should say expressly, this is where all the places where we're giving you express authority to grant the waiver. In other situations, they'll either A, have to go to the Board of Adjustments because it's a variance, or B, they'll have to use the equivalency provision. And we'll have to think about, again, do we want to open it up so that everything is applicable to a waiver? Or do we want to use this hybrid approach of waivers and equivalency provision?
So with the equivalency provision, does that give the board an ability to say, yes, you're equivalent, or no, you're not equivalent?
Yes, it does. But it's not the board, it's you. It's the planning commission.
Yeah, sorry,
It's fine. But I think it is worth having further discussions at the end of this to call out specifically where the waivers are granted. So this section also grants the zoning administrator the ability to grant some waivers as well, provided that a minor deviation results from an unintended error or unique conditions on the property, does not and will not violate the spirit of the environmental ordinance, and will not harm or have any adverse impacts. The minor administrative modification can only deviate by 10% of any standards within the code. So it's a very narrow authority for the zoning administrator. Do you have any concerns with that?
Can I ask a question, Anthony? Kevin, does that make your job easier or harder by having that ability? I'm just, on the practical side.
Yeah, I like the control of the 10%. I think that it makes our job a little bit easier because of the uniqueness of the lots in Fort Thomas and the situations in Fort Thomas that we run into. You know, there's some unfortunate situations where we have to tell people no, and if there is a little bit of latitude there, and it isn't, once again, as Lisa said, harming the spirit and intent of the language, then I think it's a good thing. I don't think it's overstepping. Now, if it said 50% or 75% or was just carte blanche, then I don't know that I would want that responsibility. I like a little black and white, but I think a 10% deviation for the uniqueness of Fort Thomas is very reasonable.
Section 111 is about for enforcement and penalties. It includes a clear list of what constitutes a violation of the ordinance, which is new. It lists a number of enforcement actions, some of which are new. These include a notice of violation, a stop work order for discontinuance, and removal of a violation. So we'll stop here. If y'all don't have any other concerns or questions about administration, we'll stop and ask for any comments, questions about administrative procedures.
So none of this is on the website, is that right? Like,
I think it's all on the website.
This was the same from last month. We didn't get to it, so it was on there last month.
Yeah, the whole section one's not on the website. But that, we can talk about that later. I was, is there somewhere that we can see what violations and enforcement actions and penalties are? Or is that not on the
No, it's all in the ordinance, it's all in the draft. Is it not on the
It
web?
should, it was on, you submitted this last month, this was all from the same from last month, so it should have been on there,
I was
but,
wondering if we do
yeah, we can find it.
Is this our chance to talk?
Can you come up to the microphone? so you can understand?
I didn't know what order.
Sorry.
That's okay. Thank you.
Hi, my name is Sharon McKnight, 62 Miller Lane. My question is about the parking waivers you're talking about, like for the central business district. Could you give me an example why you would have a waiver for a business?
So that waiver is in existence today, and it's currently in your ordinance.
Can you explain that to me, please?
So I wasn't here when it was put in.
Okay.
But I will tell you what I'm going to make an educated guess.
Thank you.
Because it is a downtown district, and it is difficult to require parking on these small lots, at that time, it was allowed to have a waiver. The waiver authority was put in the ordinance. So for example, as I understand it, buildings were wanting to, for example, go from office to medical office and couldn't do so because medical office requires more parking. And you had buildings that were standing empty. Yeah, I don't know if you were here when the waiver was put in.
No, I wasn't, but the rationale is good. We have obviously smaller lots in certain areas, and to actually change a business in the manner that Elisa mentioned, a slight change could eliminate the opportunity for someone to change it at all, and then you have a vacant building. So those variances, or I should say waivers, were put in there.
So they couldn't switch their business because they didn't have the right amount of parking spaces?
Or in some cases, they didn't have any, right? So they
Okay.
could go from one use to another use that required more parking because they didn't have it.
Okay, and that makes sense to me, because where are they going to park? Except you go down to the residential streets that are very limited in parking as it is. I mean, really, we don't have parking on these streets that are off the central business district. So if you have a waiver, I mean, I think parking should be you should have enough parking spots for your business. I think that should be pretty, or it's going to go down on residential streets. So I think that should be very mindful of the residential district, because we get their parking.
I didn't mean to interrupt.
Oh, you're
I
not.
apologize. Certainly the parking that the city has acquired is helping and should help, and more signage to drive people to that parking hopefully will continue to help that problem.
But I understand that, but if you have businesses like Forest or Woodward, it's just easier and common sense for an elderly person to park closer, maybe on the street, to get to that business sometimes. And I'm just saying, if you could be mindful with the parking. That's what I'm asking. That's what my concern would be. Okay, thank you.
Does it feel dark in here?
Yeah, we're gonna.
I like it. Take a nap.
Good evening. My name is Dennis Montoya, 40 Kathy Lane. I'm not too sure if this is the correct time to discuss this, but kind of rumor mill that I've heard. We talk about the different zones in the city. I know we talk about the single families and keeping single families that they're torn down and so on and so forth. And then I know throughout the whole city, trying to keep that in mind. And one of the things, and here again, I don't know if it's just rumor or not, I don't know if we've discussed this, but in the south end, kind of like maybe south of Hawthorne, someone mentioned that there was a discussion about maybe putting in a large multi-family complex south of Hawthorne. And here again, I'm not too sure if that's been discussed yet or if that's just rumor, but I'm not too sure with Fort Thomas. I think we have a lot of multifamilies already. My preference is keeping it no more multifamilies or larger complexes. You know, I don't think we need 50, 60, 75 units in the city. My concern would be the pressure put in on maybe school systems, city services, and so on and so forth. So I just wanted to kind of throw that out. I don't know if that's been discussed, if anything's ever been brought up about that, but just I was kind of curious if that's ever been discussed.
So that would be the Alexander Pike Mixed Use District.
Yes.
Right. And there, as it's currently drafted today, so it would only be along US 27, so it would not be any of those side streets. And as it's drafted today, they would be required to have non-residential on the first floor. And then, for example, they could have 2 floors of residential above it. But I don't know what you mean by large multifamily. I mean, it's not envisioned to be something like some of the large garden apartments that you have. Those areas are going to stay multifamily. But I don't think there's anything envisioned along US 27 like that.
Okay. And I can't remember on Newman Avenue, I can't remember the name of the apartment complex.
Pittsburgh?
Yeah, Pittsburgh. I don't know how many units, but there's quite a few.
Yeah.
And my thought was when I heard that, I said, I don't think we need another Gettysburg complex, you know, and maybe not right on 27, it could be further back, but south of Hawthorne.
Right, so anything today that is zoned, for example, R3, like there at Hollywoods or whatever, that would continue to be R3. So no large multifamily. And along US 27, truthfully, there aren't enough parcels with enough depth to create another Gettysburg, for example. But Gettysburg, I don't know what zones in R5?
R5 or R3, probably R5.
Yeah, it's probably R5. I mean, it will continue to be that. So
The way things are zoned right now, there would not be no approval in case someone wanted to tear down. I think there's some single-family homes along there. They could tear those down, push back. They could develop that.
So I can't envision Gettysburg off the top of my head, but if, for example, someone tore it all down and wanted to put up more multifamily, because it's zoned either R3 or R5, they could do so. Yes, sir.
Are you referring to the safe ship lot? Are you referring to the safe ship lot? Isn't that zone general commercial?
Today it's zoned general commercial.
And you're not changing
It would be the Alexandria Pike Mixed Use District.
So then it could be.
Well, no, but it would have to have non-residential on the first floor, but it could have some multifamily above it.
I just want to clarify what he was talking about.
Could be a one-mile.
It could be something like that. Right? But no Gettysburg.
All right, I'm just kind of curious. Thank you.
So just to wrap that up, because I left last month not knowing this, and there was a lot of discussion afterwards. So the Alexander Pike in this mixed-use district does not include the homes that are now single-family residential from Woodville to Hawthorne, correct?
Correct. The only thing that would be the mixed-use district is if it's today zoned general commercial, professional office, highway commercial, or industrial park.
So basically that's almost the rest of Alexander Pike down by the cemetery.
Down by the cemetery.
The safe ship and that and adjacent. And then all the way from Woodville down to Fort Thomas Plaza.
Some of that's zoned multifamily.
So all of that could be one island.
No, okay, because anything that is zoned R3 or R5, we're not touching.
So there's apartments there right now, that wouldn't be touched, but everything else could be one island, because what's being talked about up by Safe Ship is that NKU would bring in some sort of a student housing complex. So as long as they had commercial on the first floor, and residential above, that could be done on that piece of property.
As it's currently drafted, yes, but keep in mind all the things that we've talked about in terms of standards. So while they could have non-residential on the first floor and multifamily above, They would still have to have parking. They would still have to have all those things that are going to further constrain the lot in terms of the amount of intensity that could go there.
So what we're hearing over and over again is people don't want more density. So where's this density coming from? Is that something that, I mean, it's not in the comprehensive plan that I can see? How did this come to be?
I don't know that we're talking about a whole lot of more intensity. I mean,
Density.
Or density. I mean, it's zone general commercial today.
Which is no residential, but we're talking about adding residential on second and third floors, correct?
Some of them do allow, I'm trying to think.
General commercial actually allows that.
Yes, I think it does today.
And there's just not much of it.
It's just not much of it.
Right. So, but now we're creating the conditions for that to happen.
But no, it's already zoned that. It can happen today. Someone could tear down Safe Shop and...
But in this new zoning code, you could create the conditions where that wouldn't happen, where it would have to be commercial and no residential could be in there.
If you chose to do that, you could. We have talked about this mixed use. That's what's currently drafted. And that's what the Planning Commission has discussed to date.
Okay, I just want to be sure because I think a lot of us left last time not with that understanding and then there was a lot of talk about it, so.
But no, again, everything today that is zoned R1C, R3, R5, all of that along US 27 will continue to be that at the end of this process unless there's a major change that happens.
But down by Safe Ship and the rest of Alexander Pike, except for those areas you're talking about, could be something similar to One Highland.
It could be a mixed-use development.
And that is what One Highland is, correct?
It is.
Okay.
But I don't know that we necessarily need to keep thinking about it in those terms, because also keep in mind that One Highland is downtown. So it wasn't required to have all the parking. It wasn't required to have all the things that will further constrain intensity and density on a lot.
Okay, thank you.
Just a quick question. I'm going to follow up. I still am not 100% clear. From Hawthorne to Safe Ship, those lots, I believe, are this an RC3 or R13? R3. So those are currently residential with the exception of one multifamily building on it currently.
Okay, so.
Is that accurate? Because I think it's accurate.
So where Safe Ship is zoned general commercial.
Yeah, before, I'm just talking about, I'll get to Safe Ship in a minute. From Hawthorne, the corner of Hawthorne to Safe Ship. There's only one multifamily building in between there. The rest are residential single families.
But they're zoned R3, and they're not, that is not changing.
Okay, they're zoned R3.
There's a single family, there's like a 3-story, like multifamily, and then there's a single family, and then there's a single family.
So if those change hands, are you saying those remain residential, or they can become these big units?
So today.
Because they have deep lots.
Today, they are zoned R3. There is one apartment complex there. If someone wanted to tear it down and put multifamily up to whatever R3 allows, which I think is, they could do that. And that's what happens today. And under the proposal, that could happen under the new zoning ordinance. We're not changing anything.
Right, I understand, but you are saying if a change occurs today or in the future, that those 4 or 5 lots if sold could become a huge multi-complex. I mean, let's be fair, we're just trying to get transparency here.
No, but again, I'm not trying to be non-transparent. I'm trying to tell you.
I know.
But yes, they could become multifamily, but they would still have to meet the parking requirements. They would still have to have landscaping. They would still have to do all those things that are going to limit density and intensity.
Well, and like I said, those abut residential properties on Hawthorne, and so this is what we've been concerned about. And I actually walked the Safe Ship lot, and it's rather huge too.
It is a very large lot.
And so I guess my second question is, what if the residents wanted to change those back to a different zone?
They do not have the ability to do so. The only people.
And why did they have, okay, let me ask a question. Why did somebody have the ability to change it back then, but now we don't have the ability to change it now.
So let me finish.
Okay, I'm just trying to understand.
The city council can always rezone a piece of property, or the property owner, but no one else can. So if you want those lots changed, then you would have to go to city council.
Okay. So did city council, do we know, did city council change those back when they changed?
I have no idea.
Because somebody said they were changed back in 2002 or something. I'm just curious, like when all this happened and for what reasons, other than the city changing the zoning.
Yeah, I don't know when that changed, you know, I don't know the history on that site, specific site.
And just so you know, we're just trying to understand the process, like what the rules are, because we don't understand them. We're trying to understand them, and we definitely, you know, as we've been talking this entire time, you know, we do appreciate the fact that those are going to stay, you know, residential for now, but, you know, unless there's major density, city in a park feel barriers put up before these other things happen, when they tear them down and put them back up, I mean, that this really would not be something that we would want in a, you know, that would abut our properties. We just wouldn't want it.
But again, if they tear those homes down to put in an R3, they will then be required to meet the buffer yard requirements. They would then be required to have parking.
And do we know what those are right now?
And I don't know what the buffer yard
Okay, that's
requirements are
fine.
right now. But
I can talk to you tomorrow night about them.
Right.
Okay.
But we know that that's an issue, and so as we start to draft that section,
Okay.
we can do something about that.
Okay.
What I was saying earlier is if nothing happens on the site that goes from one use to another, we have nothing we can do about it. But if all of those homes were torn down and someone decided to put in multifamily, they would have to have a buffer yard between their backyard and your side yard.
Right. And I also think what Dennis talked about, there needs to be other considerations regarding just the density of the people and the children going to the schools. And I mean, we don't want to get to a situation where we're packing so many people into a 5 square mile situation that we kind of lose the charm of what we are. So I just wanted to say that.
Yes, ma'am. Thank you. I'm done.
I move to adjourn.
Thank you all.